before I go into the nitty-gritty of this topic, you must first understand what is the meaning of the expression Uniform Civil Code. Basically, what it says is, right, now let's come to this last important issue with respect to your directive principles. This is Uniform Civil Code, to secure which is a principle which is enshrined in Article 44 of Directive Principles. Right. Achha, now before I go into the nitty-gritty of this topic, you must first understand what is the meaning of the expression Uniform Civil Code. Basically, what it says is that laws which govern personal issues like marriage, divorce, maintenance of the divorced wife, for example, the husband has to provide maintenance, right? Then adoption, succession and inheritance, guardianship of minor kids, etc., etc. So, Uniform Civil Code means that the norms which govern marriage, divorce, things like personal matters like marriage, divorce, maintenance, adoption, succession, inheritance, guardianship, etc. They should be common for all citizens of the country. There should be common norms, laws for this, and there should be no community-based personal laws, like community-based laws which deal with marriage, divorce, maintenance, etc. All these issues differently. We know that we have community-based personal laws in our country. So basically, what is Uniform Civil Code? That laws governing these personal aspects like marriage, divorce, maintenance, adoption, succession, inheritance, guardianship, etc. should be common and should be equally applicable to all citizens. One set of laws should be there. We should not have community-based laws, right? So now, you know, when the Constituent Assembly was debating this issue and the fact that this particular article was put in Directive Principles, and the Constituent Assembly from the very beginning did not go for a uniform civil code. This was seen as primarily, that not going for a uniform civil code to begin with, was seen primarily as a concession being extended to some minorities. In particular, the Muslim minority, which was naturally at the time of the framing of the Constitution, partition had taken place. A large section of the Muslims had decided to stay back in the country. They were already facing a lot of insecurity because a lot of violence had taken place against Muslims in India and against Hindus in Pakistan. Obviously, violence had taken place against both the communities in those respective territories. Right. So, already those Muslims who decided to stay back in the country, they reposed faith in the secular nature of the Constitution. Especially, they had confidence in the personality of Nehru himself, that the sections of Muslims who decide to stay back in India, they would be treated fairly. And from the very beginning, if you impose Uniform Civil Code and personal laws that deal with, for example, the Muslim community are taken away completely from them. So, this would send the wrong signal. This would further accentuate their already existing sense of insecurity. So, one reason why, you know, immediately in the aftermath of independence and the Constitution was being framed, that we did not go for, the Assembly did not go for the imposition of Uniform Civil Code. It was largely seen as a concession to minorities, particularly the Muslims. And why particularly the Muslims? Understand one thing. You know, a Muslim personal law shapes the very identity of a Muslim person. It's a way of life for them. You know, I'll ask you a very simple thing. Does any Hindu person, any individual of any age who's a Hindu, do you know about what are the norms governing marriage in the Hindu Marriage Act? What are the norms governing divorce? What are the norms governing settlement, maintenance, adoption, guardianship? You ask a stray Indian who's from a Hindu persuasion, apart from a person who's actually, I'm teaching this particular topic, so I know some aspects of Hindu Marriage Act, Hindu Minority and Guardianship Act, Succession Act, etc., etc. But then, you know, most people outside of the legal fraternity or outside of the people who are preparing for civil services do not know much about what their personal law is. What are the Hindu norms with respect to marriage, divorce, settlement, inheritance, succession? They don't know. But, you know, if you ask a Muslim person who's even an individual who's not even properly educated, but he'll be able to tell you as to what Muslim personal law says with respect to marriage, divorce, what is the Sharia? That is the Muslim personal law, sometimes pronounced as the Shariat, or you can pronounce, the right pronunciation is Sharia, right? So what does Sharia say about marriage, divorce, maintenance, adoption, etc.? I mean, most of the Muslim persons will be able to tell you like this, it is on their fingertips. For them, for the Muslim population in particular, their personal law is a way of life. And it's the very idea of their identity. You take away their personal law, you take away their their way of life, and you take away their identity. So, because as I said that immediately after independence, we did not go for the imposition of Uniform Civil Code as a concession to the minorities, particularly Muslims. And why particularly Muslims? Because Muslims, they frame their very identity around their personal law. It's their very way of life. They know about it. They practice it on a regular basis. as opposed to other communities like the majority Hindu community, where not much knowledge is there. Knowledge diffusion with respect to what are the norms in Hindu Marriage Act, Succession Act, etc. is not there, right? Only when the marriage is to be dissolved or when divorce takes place, then the Hindu couples come to know what are the provisions of the various aspects of Hindu Marriage Act, Succession Act, norms governing divorce, etc. But for the Muslims, it's a very way of life. It's their very identity. You take away their personal law, you take away their way of life, and doing so at the time of independence, when already they were facing a lot of insecurity in the country, having decided to stay back in India when there was so much hostility against them, right? And a general atmosphere that if Pakistan has been created for Muslims, why don't they all go to Pakistan? So in this scenario, it was not considered feasible that we should immediately go for uniform civil code. So this is the reason we didn't go for it immediately, right? But in the Constituent Assembly itself, there were some voices of dissent. Many people, not very many, but quite a few liberals who were not happy with the fact that we're not going for uniform civil code. They said, we want to build this. India is a nation in the making. It was, at least during those times. They said, we need to go for national consolidation, the building of a national identity, community-based personal laws, different sections of the society being treated differently with respect to matters like marriage, divorce, etc. I mean, this goes against the very idea of national consolidation. It also, makes a severe dent on India's credentials as being a secular state. I mean, every community, every major religious community has its own set of laws. How can you call it a secular state then, right? And it will come in the way of national consolidation because different sections are subjected to different laws. So how is this even a nation then? So there is some right-minded ring to this argument which was made by some of the liberal nationalists in the Constituent Assembly that community-based personal laws would come in the way of national consolidation, would come in the way of India's legitimate claim to be a secular state also. Several women members were also opposed to the fact that uniform civil code was not being implemented. They wanted uniform civil code because they felt, and rightly so, that if you look at the personal laws of most religions, whether Hinduism or Islam, etc., most of these detailed features of these personal laws are disadvantageous towards women. But take the case of triple talaq, for example, or polygamy, which is allowed in Islam. Triple talaq has been nullified now by the Shaira Bano case of 2017, which I'll talk about as we go along. So women members were right in saying this thing that community-based personal law being framed in the ancient times, in the medieval times, when society was deeply patriarchal in nature. So community-based personal laws are disadvantageous, heavily disadvantageous towards women. They are biased towards men. That was right. And thirdly, the problem is this. When let us say a Muslim couple comes to the court, to the regular district court or a marriage court, etc., for divorce, etc., then the judge has to apply a Muslim personal law over there. If Parsi couple comes, he has to apply the norms of Parsi Marriage Act. If your Christian couple comes, then he has to apply the norms of the Christian Marriage Act of 1872, right? So and then if a Hindu couple comes, then he has to apply the norms of the Hindu Marriage Act. I mean, instead of that, if you had just one common law governing all these matters and equally uniformly applied to all citizens, then the legal system would become less complicated. There will be less burden on the legal system also. What we have today is a situation where a judge has to, if it is a Muslim couple which is subject to divorce, settlement, etc., then he has to apply Muslim law separately. He has to interpret Muslim law. Christian couple, then Christian law has to be applied. Parsi couple, then Parsi law has to be applied. Hindu couple, then Hindu law has to be applied. So it unnecessarily complicates the judicial system, the legal system, and places disproportionate burden on the judges also in terms of settling these cases dealing with these particular issues. So these were the arguments in favor of uniform civil code or against the idea of not having uniform civil code, which were advanced by liberal nationalists, women, and in general the fact that the burden of judicial legal system would become very complicated and difficult for the judicial system to administer it. Right. So any which way, as things stood at that time, we did not go for uniform civil code. Right. Interestingly, not just uniform civil code across faiths, across religions. There was one more problem in India. Hinduism is a way of life, what is Hinduism, what is Hindutva, we talked about that earlier also. And different sections amongst the Hindu fold itself, they also forget the fact that, Muslims have different norms governing those personal matters, Parsis have different norms, Christians have different norms. There was a problem that within the Hindu community itself, overall comprehend the Hindu larger religion itself, different subsects in Hinduism, different sections of Hindus themselves, they used to also practice different norms with respect to these issues. I mean, one problem is obviously that there are interfaith differences. that between Hindus, Muslims, Christians, Parsis, etc., etc., there are differences in terms of laws which govern their personal matters. But here we had a problem of intra-faith differences also between Hindus themselves. Different sections of the Hindu community, Hindu fold, different sections practicing different norms with respect to all those matters. So, one problem was to implement uniform civil code between faiths, and the next problem was obviously to first of all bring the entire Hindu community at least under one common law. You're getting my point now? So, there was absence of uniform civil code even within the Hindu fold amongst different sections who practice different norms governing marriage, divorce, settlement, maintenance, etc., etc. So, at least to provide for a uniform civil code amongst the various sections of the Hindu fold, 4 laws were enacted in the mid-1950s. They are referred to as the Hindu Code Bills to at least implement uniform civil code for all the Hindu communities, subsections, subgroups within the Hindu fold. So, what were these Hindu Code Bills? So, Hindu Code Bills basically address, as I said, the intra-faith aspect of lack of uniform civil code, to enforce uniform civil code at least within the Hindu fold to secure some kind of unification of the Hindu people who are of Hindu persuasion. So, Hindu Code Bills, what are these? Let's talk about them. The Hindu Adoption Act, 1956. Then next is the Hindu Minority not in terms of minority community, minority in terms of a child being a minor or a major, right? So, Hindu Minority and Guardianship Act, 1956 again. Then the Hindu Marriage Act, 1955. And fourthly, the Hindu Succession Act, 1956. Fine. So, at least the intra-faith lack of uniform civil code was addressed, and the Hindu community, all people of Hindu persuasions, whether they belong to this or that section of Hindu fold, were unified under 4 common laws providing for uniform civil code amongst the Hindu communities. They were called the Hindu Code Bills. These are the Hindu Code Bills. Acha, as far as personal law with respect to the others are concerned, before I come to that, mind you, these Hindu Code Bills were also made applicable to 3 more communities: Sikhs, Buddhists, and Jains. Already Article 25, when we talked about freedom of religion, there it has been defined in the explanation that the term Hindu would also include Sikhs, Buddhists, and Jains over here. But of course, these 3 communities, they have already been given the status of a separate religious minority. So, they do not appreciate the fact that the Hindu laws have been made applicable to Sikhs, Buddhists, and Jains also, right? And that's why, when Muslims oppose uniform civil code, they feel that the idea of uniform civil code is not so much to have a set of common laws applied to all citizens with respect to these personal matters, but perhaps the imposition of Hindu code or these 4 bills or 4 laws on the Muslim community, as perhaps they have been made applicable to the Sikhs, to the Buddhists, and to the Jains also. Correct. And Buddhists have been demanding, Sikhs have already been demanding this thing, that they should have a separate codification in law of their laws governing those personal matters. But for Sikhs, at least we have one law. That is just a moment, this is the Anand Marriage Act of 1909. Achha, even though this Anand Marriage Act, which applies to the Sikhs, was there since 1909, yet, Sikh marriages were still being registered under the Hindu Marriage Act. So, there was an amendment made in 2012 to finally allow the registration of Sikh marriages under the Anand Marriage Act itself, which has been existing since 1909. But because the term Hindu in these 4 laws was defined to cover all these 3 religions also, so Sikhs, Buddhists, and Jain marriages were also registered under the Hindu Marriage Act itself. So, now at least after the amendment to the Anand Marriage Act 2012, Parliament passed that amendment. Sikh marriages can be registered now under the Anand Marriage Act itself. They have a special ceremony for marriage called the Anand Karaj ceremony, so it can be registered over here, right? So, Sikhs have their Anand Marriage Act that applies to their marriages. Apart from that, for Christians, we have the Christian Marriage Act of 1872, which is a separate set of norms. Then we have the Parsis Marriage Act of 1936, which applies to Parsis. And Muslim personal law is governed by 2 very important laws, Muslim personal law. One is the Sharia Act of 1937. And then finally, we have the Dissolution of Marriage Act 1939. These are the principal laws that govern Muslim personal law. The principal acts which govern Muslim personal law, both are British time enactments, Sharia Act of 37 and the Dissolution of Marriage Act 1939. Achha, apart from this, there is also something called the Special Marriage Act. You probably are familiar with this because this was in the news in the recent past only on account of a judgment that came from the Allahabad High Court. Right. So this is from 1954. Now, the Special Marriage Act is the act under which the so-called civil marriages are performed. It is religion neutral, it is faith neutral, it is caste neutral. Anybody who wants, any couple who wants to have their marriage registered under this particular law, they can do so, right? But usually couples who are of different faiths, interfaith marriages, intercaste marriages, usually tend to get registered under the Special Marriage Act 1954. Otherwise, it is faith neutral, it is caste neutral. Anybody can have his marriage registered under this particular law. It is basically this is the law under which the so-called civil marriages. Before a magistrate, you have to sign that register, and civil marriages take place under this particular law. It is faith neutral, caste neutral. Any couple can have their marriage registered under the Special Marriage Act of 1954, but usually couples who are from different religions, interfaith marriages, interreligion marriages, intercaste marriages tend to get registered under the Special Marriage Act 1954. Correct. Achha, now, in this Special Marriage Act, there was a provision, now in the recent context why this was in the news, there was a provision that any couple which is seeking to get married under this particular law to solemnize a civil marriage has to give a 30-day notice. Right. So this 30-day notice period was largely there to ensure that, if somebody has an objection to this marriage, some legal issues or things are there, or maybe the couple, one of them, male is already married to someone, he's hidden that fact, any kind of objections. So 30-day notice period is largely given to provide for the opportunity for any person who wants to raise an objection to this particular marriage. It could be a serious legal objection also, he can do so. But usually this 30-day period has been exploited by parents. The typical Hindi film example would be couples who run away, especially when their parents are opposed to the marriage of their kids, boy and girl obviously, right? So when they run away, they tend to get married under this law, but 30-day notice period means notices are then sent to their addresses also, and then the parents come to the court, they object to the marriage, and they come in the way of the marriage being solemnized. Achha, in the recent past, because as I said that interfaith marriages are solemnized under this, so in the recent past, because of that rather senseless concept of love jihad, etc., especially when there is a Hindu-Muslim marriage bond, and especially when the male is Muslim and the bride is from Hindu persuasion. So 30-day notice period has often been used to exploit that particular aspect. Wherever they find that Hindu and Muslim marriage is going to be solemnized, so in the 30-day notice period, all kinds of nonsense takes place, pressurizing the couple, pressurizing the parents. Sometimes they have been subjected to violent attacks also, right? So this 30-day notice period was largely there to allow somebody, if he wants to raise objection, they can do so. But as I said that, this has largely come, this 30-day notice period has largely resulted in, the consequence has been harassment of the couple, and particularly with the rise of this concept of love jihad, harassment of interfaith couples. Right. So Allahabad High Court, I think it's a good decision now that Allahabad High Court has done away with this period. They said it's optional. If a couple wants to give this notice period of 30 days, it can do so. If it wants to go ahead with the marriage immediately without giving this notice period. So Allahabad High Court this year, 2021, has done away with this 30-day notice period. Are we okay with this thing? Okay.